This conference will now be recorded.
Hello, and thank you for joining us for the Safety Officer Presumptions Webinar presented by RTGR Law. We're going to talk today about the presumptions that apply to public safety officers and related personnel, mostly applicable to California public agencies. The first thing I want to do is apologize in advance for any technical difficulties, the sound quality, and the fact that I'm recording this webinar in one take, so there'll be no editing, and you may hear the occasional unintended off-script item, and for that I apologize. And the reason we're doing that is because I'm recording this in the midst of the COVID-19 pandemic, and we've heard from a lot of our clients that what they really need right now is on-demand continuing education that they can view from the comfort of their home or office, most likely home, without having to attend at any specific time or in any specific place. So we're putting these together fairly quickly for the benefit of our viewers. Usually, the attorneys of RTGR in our offices across the state of California, when we have a PowerPoint program that our clients have asked for, such as this one, we will go to our client's office and set up in the conference room, and everyone will come and assemble in the conference room and watch the PowerPoint, or as we've been doing more recently, we'll present the PowerPoints through a webinar, live webinar format, whereby we have clients call in at a specific time, say Tuesday at 10 o'clock, and everybody logs in from their conference room or their cubicle and watches the presentation live in a PowerPoint format, and they can ask their questions by chat or by over the speakerphone as the PowerPoint is being presented. But right now what's happening is even that is a little bit too inconvenient for folks, because there are, for example, claims folks who are, and employers and HR people who are having to work from home. They may have kids who are off school, and as a result, attending on a Tuesday at 10 o'clock may be pretty inconvenient if you're changing diapers or having to make lunch for toddlers and things like that. It may be more convenient for that person to attend at 10 o'clock at night. But that doesn't always work out. Not everyone can be available at 10 o'clock at night. It's not the ideal time to have a webinar or a PowerPoint. So what we're doing is we're recording several programs, several of our existing programs, and creating new ones and presenting them on a on-demand webinar format. And this is one of them. So what's going to happen today is the PowerPoint will proceed with, and you get to watch it anytime you like, and you'll be able to send in questions as you're watching the program by email. And I'll give you those emails in just a moment. Or you can send the emails later after you've watched the program, whenever it's convenient, and we'll get back to you with the answers to questions. We suspect that we'll probably get the same question more than once, and in which case we'll compile those and send perhaps an email with answers to several questions. So first things first, this is a very general information that I'm presenting today. This is for educational purposes and informational purposes. If you need specific advice or you have questions about a specific legal issue, please reach out to us, and we're happy to answer those. We do that for clients and all the time, whether it's related to a case that we're handling or not. we're happy to do that. This is the office. These are our offices across the state of California for RTGR Law, where you can send your questions. You can send your questions during the program. You can send your questions after the program. What you should do, I think, right now is locate your closest RTGR Law office. Each one of these emails, for example, the Oakland email address, oak@rtgrlaw.com, is monitored by one or more partners in the firm. So, or senior attorneys who happen to be the most senior attorney in that office, in that region. So we figured it was best to have the question go to that individual, even if the person recording the webinar is someone different, because that person will not only be able to answer your question, that person will also be able to answer it in the context of your region. So for example, if you're asking about an issue you're having with a particular applicant's attorney in Van Nuys, the email will go to our partner in Van Nuys, who will be familiar with that attorney and the judges and all the doctors in the area and who's the best doctor to use to address a particular presumption. So just know that these emails are monitored. I wouldn't say 24/7, but pretty frequently, each one of them by the most senior attorney in each of those offices. So there you go. And I'll have this same or a similar slide with these email addresses at the end. But if you want to find your closest office right now and just jot down that email address, you'll have it. And you can start sending email questions as you're watching the program. So let's talk about presumptions of injury. In California, we have several presumptions of workplace injury. We're going to talk today about the safety officer presumptions, or the presumptions that apply mainly to police and fire and similar occupations. These are presumptions, by the way, are what we call legal fictions. Fictions like a novel is something that's sort of made up. And the reason we call it a legal fiction is because the presumption sort of creates the legal finding, if you will, that something happened even though we don't know if it really did. So for example, if a certain individual sustains or unfortunately develops a cancer, if that individual has no job, then their cancer is obviously not compensable for workers' compensation purposes. If that person works in any of a number of noble professions, such as a school teacher or someone who's a farm worker, or any of a number of different jobs in California, it is very likely that their cancer will not be found to be related to their employment, even if they could possibly argue that maybe there were some carcinogens that they were exposed to in the workplace as a farm worker or as a teacher. It's going to be very difficult for them to prove in court or at the Workers' Comp Appeals Board that that cancer was caused by that job. What the presumption does is it creates a legal fiction, and it says that for certain classes of employees, for example, firefighters, if a firefighter develops a cancer during their period of employment for a fire department, we're going to assume or presume that the cancer was caused by work. So the result is that particular employer, that firefighter, as opposed to the teacher and the farm worker, has a benefit when going to court, going to the WCAB to establish a work-related injury. They've got, if you will, they've already got the door open to them, and they have very little, if anything, to prove to make their workers' compensation case compensable and receive workers' compensation benefits. So all these presumptions, that's basically how a presumption works. And we're showing you a map there of the state capital, Sacramento, because all these presumptions come from state law, passed by the legislature and signed by a governor at some point. So let's talk about the presumptions of work injury. Generally, who qualifies for these presumptions? Well, not teachers and not farm workers, but folks who do qualify include police officers, firefighters, and other public service department personnel. We'll talk about the specific presumptions and the specific individuals who qualify. And they generally cover cancer, heart trouble, hernia, bloodborne infectious diseases, most recently PTSD, and other conditions. So we'll talk about those. Generally, the person has to be engaged in active law enforcement or active firefighting prevention to be covered, but that is definitely not always true. And so we'll talk about that. What's the effect of the presumption? Well, I talked about that just a moment ago, but what does it mean to have, I guess what I should say is the statutes go even further than what I mentioned before in the earlier slide. It's not just that the presumptions create an assumption or presumption that work caused the injury. They go further. And legally, they go further than that by having anti-attribution clauses often. And what that means is the employer, even if, for example, a firefighter developed lung cancer, and it's presumed that the lung cancer was the result of their employment. They developed that cancer while they were working. Maybe they'd been on the job for 20 years and they'd fought many fires and had breathed, despite the despite the apparatus designed to keep, and equipment designed to keep the smoke out and away from the firefighter, breathing apparatus, for example, the person still at some point is going to breathe in some of that smoke or some of those particulates. So they have exposure. And the presumption doesn't just create a presumption that workplace risk was the cause of the injury. It actually has oftentimes anti-attribution clauses, which means that even if that same firefighter who'd been on the job for 20 years had a 30-year history of smoking a pack of cigarettes a day, and medical science would indicate that actually smoking cigarettes is more likely the cause of the direct cause of the cancer in his lungs or her lungs, the presumption says, well, you don't even actually get to present that evidence of smoking as the true cause. So it's anti-attribution, which means you cannot attribute the cancer, or the employer cannot attribute the cancer at court to these non-industrial causes, such as cigarette smoking. So the anti-attribution clause, the effect of the presumption is far stronger, if you will, in favor of the employee than simply creating that initial legal fiction of causation. It actually closes the door on other potential causes. The other effect of these presumptions is that most of them have a prohibition against apportionment to non-industrial factors. So we know we can't use that firefighter's 30-year history of smoking to rebut that presumption of injury, for example. We know that. But now, recently, 4663E of the Labor Code was passed, which says that even if a doctor says, well, okay, in light of the presumption, I'm going to attribute 50% of the cancer to work, 20 years of breathing fires as a firefighter, and I'm going to attribute 50% of the permanent disability, the other 50% to 30 years history of smoking, which would, in a normal case, result in the employee receiving about half of the permanent disability award. Well, for presumptions, 4663E says no, you don't get to apply apportionment of permanent disability to non-industrial causes. So that's the other effect of many of these presumptions. 4663E doesn't apply to every presumption, but it does apply to most of them. So let's talk first about the cancer presumption. It's definitely one that involves quite a bit of scientific evidence and medical legal discovery, because cancer itself is a complicated disease process, and the science on cancer is changing and changes, and new evidence comes up as far as causation of cancer and how it develops, and it becomes relevant in these workers' compensation cases. The cancer presumption applies to active firefighters, including volunteer firefighters. And it covers most peace officers, those who are sworn under California law as peace officers and active in law enforcement activities. It will apply if the employee can establish that the work exposed them to any known carcinogen, and if the cancer developed or manifest within a certain statutory timeframes, for example, during the course of their employment or for a limited period of time afterwards. The exposure to the known carcinogen, by the way, is not specific to the particular type of cancer. So, for example, if a firefighter develops a cancer that the most common cause is exposure to benzene, a type of a chemical, the employee does not have to establish that he was actually exposed to benzene during the course of his employment. The way the cancer presumption works is it's sufficient for that firefighter to establish that he was exposed to any carcinogen, such as wood smoke, in order for him to have the cancer presumption apply. So he doesn't have to prove that he was exposed to that particular carcinogen that is most commonly associated with his particular cancer, just that he was exposed to any carcinogen. So AB 1400, this became law in this year, January 1, 2020, as I record this this year. It extends the cancer presumption beyond the folks who would normally qualify. As I said in the beginning, mostly cancer and other presumptions apply to active duty firefighters and active duty peace officers. Well, this presumption goes further and extends it to all fire department personnel who are exposed to fires and the hazards directly resulting from firefighting operations, not just active duty firefighters. So this could include, for example, on-scene dispatchers. That is, dispatchers in some big fires, dispatchers will actually be present at the scene to assist in the actual dispatch of the fire suppression equipment and personnel. EMTs, who may be at the scene helping with the victims of the fire, who are not active duty firefighters, but EMTs employed by the fire department. It could also include fire marshals and inspectors who may be present after the fire, for example, to inspect the cause of the fire. But even after the fire, let's say you might still have smoking embers and residue, ash, tar, other carcinogens that are still present after the fire has already gone out, and those people will certainly be exposed to those hazards if they're present on the scene, walking around, inspecting things. Could even go so far as to include mechanics and other folks who are employed by the fire department to maintain the equipment, because when they're washing those rigs of all that soot and dust and smoke, they are exposed to those carcinogens and those hazards that are directly the result of firefighting operations. So you see that the scope of this statute is pretty broad. It does cover, it says in the statute, fire department personnel. So presumably, for example, in the case of a mechanic, if that mechanic was employed by the fire department, washing those rigs and being exposed to the firefighting equipment after a fire on a routine basis, and then that person was employed by the fire department itself, she, as a mechanic, would be covered by this presumption. Now, if that same mechanic did the same exact job, but did not actually work for the fire department, perhaps the rigs are brought somewhere else to be cleaned, and the people doing that service are other employees of that agency, that city or county with a fire department, but they actually work for general services or some other department, presumably that individual would not be covered by this statute because they're not actually an employee of the fire department. Similarly, if the fire department outsources the cleaning of the equipment to, an outside company, a private company, those people would not be covered as well because they're not actually employees of the fire department. At least that's how the law is written. We'll see if that's how it's interpreted by the courts. It's so new that we don't quite know where the courts will go with it. So the cancer presumption, as I've kind of covered, is really difficult to rebut. Once it's raised, once the employee meets the criteria of establishing that they fall within the class of employees that are covered by the presumption, the cancer occurred during the course of their employment or within the statutory time frame, and they were exposed to a known carcinogen of some kind, they're pretty much home free as far as it goes to prove that the cancer was work related and receive workers' compensation benefits without apportionment. But it is possible to rebut cancer presumptions, and we have done it at RTGR Law. We have succeeded, and other people have succeeded by carefully understanding how the cancer presumption works and the basis and mechanism by which the presumption is rebutted. So it can be rebutted by a defendant, the law states, if number one, the defendant establishes the primary site of the cancer. So the defendant has to prove with medical evidence, where is the cancer? And probably what type of cancer are we talking about? So where in the body did it occur? And the second thing, primarily occur, I should say, because cancers, of course, can metastasize and spread, but where was the primary site? Where did it start? And then the second piece is to affirmatively establish that there is no reasonable link between the carcinogens to which this person was exposed and the cancer. So it's often required that the defendant produce a specific study that states that a specific carcinogen is not reasonably linked to a specific cancer. And the problem is those types of studies are pretty rare. But that's how high the bar is for a defendant to rebut the presumption. It can be done. It's difficult to do. So just to be clear, the fact that there's no existing medical studies that show a link between the cancer and the exposure does not rebut the presumption. So it's not enough to say that, hey, Judge, we've looked at every single medical study out there about this particular type of cancer, and none of them say that there is a higher incident of this cancer for firefighters or police officers or whoever the employee happens to be. And none of them indicate that the carcinogens to which this person was exposed have any relationship to the cancer whatsoever. That's not enough under the Garcia case, because the presumption will apply, and really it's the defendant's job to produce the scientific evidence that says it does not have a reasonable link between exposure and the primary site of that particular cancer in this particular employee. Furthermore, a genetic predisposition to cancer is not, or a particular cancer is not sufficient to rebut the presumption. So the fact that that employee is at a greater risk by genetics than the employee next to them is not sufficient to rebut the presumption. Now, one defense that does work is what's called the latency defense. And the way the latency defense works, it's the same defense that we've just been talking about, but you're using latency, or the time it takes for exposure to turn into cancer. That is for the carcinogenic, whatever. The time it takes for the cancer to develop after the exposure to the chemicals, to the carcinogens that actually cause that cancer, the time is too long for purposes of a particular workers' compensation claim. So latency works for the defense by demonstrating, especially for short-term employees, that medical studies suggest that it takes, let's say, 10 years between the last instance when the person was exposed to the carcinogens which caused the cancer and the actual development of that cancerous tumor, for example. It's not unusual for there to be a period of years between the exposure and the development of the tumor. It's oftentimes a very slow process. So what latency says is basically the exposure that the person may have had over the last 5 years or even 10 years really isn't relevant to the cause of the cancer. It's the exposure from the years prior that actually caused the injury. Well, if that person was working for your agency for the last 20 years and there's a 10-year latency period, the latency defense isn't going to do much good. However, if that employee is only a 5-year employee or a 3-year employee, then the latency defense may have much more teeth and may be effective in rebutting that presumption. It means that the person can look perhaps to employers from earlier to claim workers' compensation benefits, and that actually happens fairly frequently as well for lateral employees who move from one agency to another. It may turn out that the earlier employer is liable, or no employer if the person wasn't working back then. So that's the latency defense, and it does have some teeth. Another way to look at the defense to cancer presumptions is, again, going back to the primary site of the cancer. We've had cases where, for example, people have developed cancer on a part of the body that would not be exposed to sunlight, and the cancer itself, in the course of their job duties, and the cancer is, for example, in the middle of the back. And the cancer is one that the primary site is established, the middle of the back. Medical studies demonstrate that the only known cause of that cancer is sunlight, photon radiation coming from the nearest star in our solar system. And that, well, the only star in our solar system and the nearest star in the universe, that sun exposure is what causes this particular cancer on the middle of the back. So what we've done is we've established the primary site of the cancer, the scientifically and medically known cause of that cancer, carcinogenic cause, which is of sunlight. And we've established that there's no reasonable link between that exposure and the work, because the person always wore a shirt, of course, during their work as a police officer, for example. So they were never exposed to sunlight in the course of their job duties. The same defense wouldn't apply, for example, to a lifeguard. But that's the way that this rebuttal of the cancer presumption can work. So going back to latency, in addition to the latency defense, for latency defense, as in all of these questions of rebuttal of the presumption, we will need AME and QME opinions. We need really good medical legal reports to address these questions. And oftentimes with latency period, different doctors have different opinions as to how long the latency period will be. And some of them have different opinions as to even the primary site of the cancer. So knowing which doctors tend to report in a particular way, and actually more importantly, knowing which doctors who know what they're talking about when it comes to what is essentially oncology, cancer causation, that becomes very important, because sometimes the panel, for example, of oncologists available as QMEs is very small, if any, and the more likely you're going to wind up with an AME or QME who's an internal medicine doctor with a wide variety of expertise, but not necessarily a narrow expertise in cancer causation. So part of our job may be to educate those doctors and certainly try to find the doctor with the best our closest proximity to an oncologist who can offer an opinion that's reliable. The WCAB has suggested that defendants need to establish a specific latency period for specific cancers through medical studies, which would be very difficult to do because not every cancer has a specific latency period. Because medical studies require a lot of money, and sometimes it doesn't make any sense for a university or an institute to spend a lot of time studying the latency period of a particular type of cancer. Sometimes they do, but not for every cancer. And if that was the requirement, then that would result in the cancer presumption being really not a presumption, but just a conclusive injury. Which is something different, which means that basically all you have to do is claim the injury if you're the type of employee who's covered, and there really is no defense. So if the Bigelow case stands, I think it's probably raises the cancer presumption to a cancer conclusion rather than a presumption. But we've been successfully arguing against Bigelow and demonstrating, again, through solid AME or QME opinions, well-reasoned, that scientific evidence that shows that this cancer is similar to, let's say, cancer A that is relevant in the case is similar to cancer B, and cancer B has been well studied, and there is an established latency period for cancer B. And again, cancer A is very similar, has a similar makeup and a similar genetic constitution. That may be enough for the judge to accept, the Workers' Comp Appeals Board to accept that the latency period for cancer B and cancer A are similar. So that's the latency period for as a defense to the cancer presumption. As I mentioned a little bit earlier, the cancer presumption actually extends beyond, well beyond actually, a person's employment as an active duty firefighter or police officer, or as we've talked about, non-firefighting personnel in a fire department. The cancer presumption will extend for 3 months after their last day of work for every full year of service, for up to a total of 120 months. That's 10 years after the person's last active service. So for example, if you have a firefighter who retired, who had sufficient number of years of service that they would be entitled to 120 months post-retirement, and they develop a cancer 9.5 years after they took a service retirement from the fire department, the cancer presumption would still apply to that individual 9.5 years later. The fire department may not even remember who this person was. They maybe have been retired for so long, but that could be not only a claim that can be filed, but presumed compensable cancer case. This statute, by the way, is from the last day actually worked, not the last day that they were on the books. So oftentimes with safety officers, they stop working for up here, and are paid workers' compensation benefits. Maybe they've run out their sick and vacation time and so on. And then then there's a retirement date that comes later. And though they're finally off the books and no longer considered to be an employee, it might be even years after they actually last worked as a firefighter. What the statute is looking for here is the actual last day of work as a firefighter, for example, not the last day on the books. So let's move on to the other big one that comes up often in California workers' comp, which is the heart trouble presumption. And the heart trouble presumption applies to fire department personnel. These are active firefighters now we're talking about, and sheriff's office personnel. So for example, deputy sheriffs and all the other safety employees that we think of when we think of these presumptions, generally speaking. 3212.5 of the Labor Code extends that same presumption and works pretty much the same way to police officers in cities or municipalities. 3212.5, and the reason I distinguish those two sections is 3212.5 has a 5-year clause. So the person has to actually work as a police officer for 5 years before they are covered by that heart presumption. Firefighters are covered from day one on the job. The heart trouble under the presumption is considered to have manifested when it's discovered by simple diagnostics. It doesn't have to be associated with symptoms or restrictions. So to qualify for the heart trouble presumption, an employee doesn't have to have a heart attack or have to have, pain in the chest or other symptoms associated with heart trouble. It is sufficient if there is diagnostic studies that show that the employee has what's considered heart trouble, and they may be completely asymptomatic. And they may have just gone in for a routine physical exam, and a doctor says, hey, guess what? You have such and such wrong with your heart. You may not be having any symptoms, but it's there. I see it on this scan or this study. All of a sudden, they have heart trouble, and they're covered by the presumption. So what is heart trouble? That's an important question. There's no strict legislative or judicial definition of heart trouble. It's the definition is the 2 words, heart trouble. So the cases have been sort of all over the place and have addressed this over the years. A heart tumor falls within the presumption. So that's a tumor actually on the organ, on the heart. Aortic valve disease does constitute heart trouble. The aortic valve is right next to the heart muscle itself and pretty much considered to be part of the heart, the valve itself, because the valves open and close and help the heart do its job. So that's considered to be heart trouble. LVH is a big one. I say big one because it comes up quite a bit. It's one of those symptoms. Well, it's not really a symptom. It's one of those conditions which appear on diagnostic studies, and there are physicians who have, different physicians have different opinions as to exactly how big the left ventricular has to be abnormal. And when it becomes abnormal, it's considered to be to constitute LVH, and that again is oftentimes completely asymptomatic to the individual. It just comes up on a diagnostic study, and it does constitute all by itself heart trouble with or without symptoms. Now, hypertension alone is not heart trouble. Hypertension often leads to, over years, leads to other medical conditions that do constitute heart trouble. For example, LVH is a consequence of hypertension often, but not always. So remember that. It's an important point that hypertension alone is really a cardiovascular problem. It's not trouble of the heart. A cerebral stroke was held not to be heart trouble, even though it had some relationship to the cardiovascular system. The stroke itself was in the brain, and so it was not considered to be heart trouble. Arteriosclerosis is not heart trouble, absent a connection to a cardiovascular problem. So for example, you can have arteriosclerosis in your legs. That is a cardiovascular issue in the legs. It's not part of the heart muscle. Two isolated incidents of tachycardia were held not to be heart trouble when there was no reoccurrence, and the worker's chest pain was found to be non-cardiac. But atrial fib is considered to be heart trouble. So our atrial fib is more of a systemic problem, something that does recur. So this is the distinction between those two things. The heart trouble presumption can be rebutted, and it's almost as difficult to rebut as the cancer presumption. It's one of these other presumptions that's so close to being impossible or difficult to rebut that it's almost a conclusive. It's also almost a conclusive injury rather than a presumptive injury. Courts have held that heart trouble presumptions can be rebutted by some contemporaneous non-work related event, such as strenuous recreational exercise like deep sea diving that was the sole cause of the heart trouble. In that case, the off-duty, I think it was a police officer, was out of state, deep sea diving, and he had never really done it before. That is a recreational activity that is quite strenuous. It puts a lot of stress on the body, on the heart itself, and it was found that the person would not have had the heart trouble had he just been on the job doing his job. This was related to that specific event, so it was the heart trouble presumption was rebutted in that case. If there's medical evidence that shows that alcohol consumption contributed to the heart trouble, that's not sufficient to rebut the presumption, but there has been at least one case where the doctor found that the alcohol consumption was so bad, so systemic, that it was the sole cause of the heart trouble. Then the defense was able to rebut the presumption. So you can have non-industrial conditions such as pancreatic cancer, which cause a blood clot leading to a stroke and a heart attack, and that can, for example, you can disprove the presumption or rebut the presumption. Strenuous off-work jogging, at least in one case, was found to be the cause of the heart trouble, not work. However, what's happened lately is a lot of off-duty police officers, firefighters, and so on will claim that their off-duty recreational activities such as jogging or even basketball playing was actually work-related, even though they were doing it on their own time and with their friends, because they had to stay in shape for their job. And that's a point of dispute, not just for heart cases, but for knee cases and all sorts of cases. And I've had plenty of those cases over the years, and we've been successful in many of those cases. But that's how it can come up even with the heart trouble presumption. So like the cancer presumption, the heart trouble presumption does apply to folks who have already retired or are no longer working for the agency. This presumption is limited to 5 years. It works sort of the same way, where it will apply 3 months of extension will apply for every full year of service as an active duty safety officer, up to a total of 60 months in the case of heart, as opposed to 120 months in the case of cancer. And the same as in the cancer presumption, the time runs from the last day actually worked, not from the last day on the books. Okay, another big thing that happened in 2019 that became law on January 1, 2020 is the PTSD presumption. So the PTSD presumption is something that was really hard fought in the legislature. It had been kicked around for several years, I believe, and finally became law last year and was signed into law. So this is the newest presumption, and it is something that's going to present particular challenges to public agencies, in my opinion. The presumption was part of a Senate Bill 542. And what it does is it creates a rebuttable presumption of psychiatric injury for active firefighters and most sworn peace officers for injuries on or after January 1, 2020. So that means that if the incident of PTSD arose from an event in 2019, then this presumption would not apply. If the incident occurred in March of 2020, then it would apply. Once the PTSD is claimed and diagnosed by a treater or a medical legal evaluator, the burden of proof shifts to the employer to prove that there was no injury, which is an already difficult task to do, given that PTSD and psych injuries are subjective and some would say speculative in nature. And what I mean by that is, for example, with a cancer presumption, there's not a lot of speculation. There's some, but not a lot. If a person has a biopsy and tissue is sent to a laboratory and reviewed by a person with a microscope, and there are pursuant to certain scientific protocols. The cytotechnician is able to look at that tissue sample under a microscope and make an informed decision that, yes, that is a cancer. It is this type of cancer. And they write a report, and the report is adopted by a physician. That's fairly objective. That's a fairly objective way. If a person has a heart attack and their chest is diagnostically studied, and they look at the heart, and the cardiologist says, yes, there's the evidence of, tissue death in the heart as a result of that heart attack. And you have clearly, objectively, you've had a heart attack. That's fairly objective. But with PTSD, there is no such study. There is no scan. There is no MRI. There is no blood test. There is no way. There's nothing to look at under a microscope other than a person's psyche, if you will, which is, again, just subjective. It's based on what a person believes, in this case, a psychologist or psychiatrist, rather than something that shows up and a technician can actually read or diagnose objectively. So this is why the PTSD presumption presents particular challenges. We haven't had any cases on this. There will certainly be some. And many of those, I suspect, will surround the defenses to the PTSD presumption. So the PTSD presumption is very unique from other presumptions in that the definition of what constitutes PTSD and qualifies for the presumption is very, very specific. I mentioned earlier that heart trouble has really no statutory definition. The statute just says heart trouble. Well, this statute has a very specific definition of what constitutes PTSD. It has to be PTSD as diagnosed according to the most recent edition of the DSM, which is a manual put out by the American Psychiatric Association. The current edition is 5th, and it's very detailed. It has a very detailed list of criteria under that DSM, which allows a physician to properly diagnose PTSD. So that's one big thing to look at in every one of these PTSD cases. Another thing to look at is the fact that under the statute, the PTSD has to develop or manifest itself during the service of that employee's service within the department or agency. And again, as with the other presumptions, it can also arise up to 5 years after their service. Once again, 3 calendar months for each full year of service, extending up to a total of 60 months potentially from the day, once again, last day actually worked as opposed to retirement date. So those are 2 things we really want to look at when we're looking at are there defenses available to the PTSD presumption or a PTSD claim. More defenses are in the statute. One is that this presumption will not apply unless the safety officer has performed services for that department or unit for at least 6 months. So this presumption doesn't apply to brand new hires. Instead, they have to be on the job for at least 6 months. Apparently, it does not have to be continuous. So it could be 3 months at one agency, and then maybe there was FMLA leave or some reason why they were off work, and then they came back for another 4 months. That person would qualify. It doesn't have to be continuous. There's also an exception to this rule, this 6-month rule, if the PTSD injury was caused by a sudden and extraordinary employment condition, which is not defined by the statute. So if that is a employee who's only first day on the job and they claim PTSD, but they're claiming it was due to a sudden and extraordinary employment condition, which we don't know what that is, but if that's their claim, then they might be able to get around that 6-month rule. So there's some questions that remain regarding the statute. Again, it's brand new, so we have a lot of questions that the courts are going to be answering. One question is whether the good faith personnel defense continues to apply. to this presumption. The good faith personnel defense applies to all psychiatric injury cases as found in Labor Code section 3208.3. And what the good faith personnel defense does is, let's say that a person has been disciplined or is being terminated, and in the course of those personnel proceedings, he or she claims a psychiatric injury. Well, in California, if the employer can establish that the good faith personnel action that was going on at the time was the substantial cause of the psychiatric injury, then the claim is not compensable. We don't know whether that good faith personnel defense applies to the PTSD presumption. I would argue it does, because Labor Code section 3212.15, which is the section that establishes the PTSD presumption, it makes no mention of 3208.3, which is an earlier existing law, and it doesn't say that those defenses found in 3208.3 are inapplicable in this for this presumption. So arguably, the good faith personnel defense still applies. Another thing which seems to also apply is apportionment of permanent disability. The cancer presumption, the heart presumption, we know from our discussion, do not afford the employer apportionment to non-industrial causes. That's why we cannot attribute the firefighters 30 years of smoking cigarettes that we talked about earlier to non-industrial causes. We cannot apportion 50% of that permanent disability to the smoking, because Labor Code section 4663E says that you cannot apportion to non-industrial factors in the case of the cancer presumption. But this PTSD presumption is not among the listed statutes under 4663E. There is no bar to apportionment to non-industrial factors in the case of the PTSD presumption, or at least none that I can find. So there's the PTSD presumption. Is going to be an interesting one as it develops. There are other presumptions that arise in California law. One is the hernia presumption. This applies to firefighters and safety officers. It has a non-attribution clause, as we've talked about, and it does extend up to 60 months post-retirement. Works the same way as the other presumptions that we've talked about. There's a pneumonia presumption for firefighters and certain safety officers. When you're looking at these presumptions, you always want to check and see, does this individual who's making the claim, do they qualify based on their job classification and their years of employment for this presumption? So in pneumonia, you always want to go back and check the statute and see who qualifies. Bloodborne infectious diseases, certain safety officers and firefighters qualify for that presumption. Also the MRSA presumption. These presumptions all have non-attribution clauses as well. There's a low back injury presumption. This one's fairly recent. It's what we call the duty belt presumption. It does apply to police officers who for the last 5 years, or for at least 5 years, I should say, had as part of their full-time job the expectation of wearing a duty belt, and the requirement were actually wearing a duty belt as a condition of their employment. So for example, a patrol officer who's wearing a duty belt and going out on patrol for 5 years or 6 years, that individual will qualify for the low back injury presumption. It also has a non-attribution clause, and it extends up to 60 months. And this is something worth definitely looking at, because sometimes police officers will rotate through different types of assignments. So maybe the police officer was a detective for several years and didn't actually wear a duty belt. Maybe she wore a gun in her vest, or a gun in her sport coat, or wherever a detective wears a gun, but didn't actually wear a duty belt. If you're trying to be an undercover detective and you're walking around with a big patrol officer duty belt with a billy club and all those other things, you're not going to be undercover very well. So detectives have their, may have similar equipment, but it's worn in a different way other than on a duty belt. And that individual may not qualify for the presumption if they spent years as a detective, or years as a bailiff in a jail, or years doing some other duty as a police officer that didn't require wearing the duty belt. So this slide was recently added. As you can imagine, COVID-19, the coronavirus, is not presumed compensable. This is a question that's been brought up. Is COVID-19 a statutorily presumed injury for safety officers or healthcare workers? And the answer is no, it is not statutorily covered. It wasn't even known of until relatively recently. Now, if a public safety officer were to develop pneumonia, which seems to be an unfortunate consequence of COVID-19 infection in some cases, if that officer were to develop pneumonia because of the COVID-19, it could raise the pneumonia presumption if the pneumonia developed during their employment. Now, the presumption might be able to be rebutted, the pneumonia presumption, if you can establish that the COVID-19 itself was non-industrial, that disease, the underlying disease. We're going to talk about exposure and strategy that presumptions create. The presumptions do cost public agencies because they do generate additional exposure to those public agencies. For example, presumptive cases carry with them certain benefits that other employees do not receive. So 4458.5 of the Labor Code states that for certain presumptive injuries that arise after retirement or termination of service, the worker is entitled to the maximum rates for temporary disability and permanent disability. So even if that person wouldn't otherwise qualify for maximum temporary disability rate because they're retired, they're still entitled to that maximum rate under the statute. A worker may be entitled to that maximum rate even if they fully retired and just haven't worked at all. They've just been puttering around the garden and doing hobbies and not earning any income. They may still qualify for those maximum benefits. These presumptions do cost public agencies and the taxpayers who fund public agencies. The costs include direct costs to the agency for workers' compensation benefits, because there may be a cancer or PTSD that would otherwise be not compensable for the same agency's other employee in a different department. Maybe someone working in Health and Human Services develops a cancer or develops PTSD or claims to, and alleges it's work-related. That claim may not be work compensable and benefits may not be owed. But in the case of firefighters or police officers who qualify for the presumption, it's almost certainly going to be owed, or very likely, and that's direct cost to the agency that wouldn't otherwise be borne by the agency. There are indirect costs to the agency from these presumptions, and that comes a lot of times from overtime that other officers and firefighters have to put in, because when people go out on a presumed compensable injury, they may be away from their job for a period of months or even years, and the department can't fill their position with another active duty firefighter or police officer, so they have to operate short-staffed and pay people overtime to fill those shifts, and that creates indirect costs to the agency. And there's also an increased burden potentially on the state's retirement systems. CalPERS and local county and other municipalities have what's called 1937 Act retirement systems. In those retirement systems, certain classes of employees, usually public safety, can qualify for industrial disability retirements. We call them IDRs. Those can be very expensive for the agency, for the public retirement systems that provide those benefits to a whole bunch of employees. And those folks wouldn't otherwise qualify for an IDR absent the legal fiction of the statutory presumption. So these are ways in which presumptions cost. There are strategies to mitigate these presumptions, however, and these strategies include, first of all, always checking to verify that the claimant in question qualifies for that particular presumption based on their job classification, based on their years of employment. Also, so first of all, does the person qualify? Secondly, what is the exact diagnosis? doesn't meet the statutory definition. In some cases, there could be a cyst or a tumor. It turns out it's benign, it's not cancerous, and so it wouldn't qualify for the cancer presumption. And most recently with PTSD, if it doesn't meet the very specific and strict criteria for PTSD under the DSM, then it does not qualify for the statute. Even if the presumption does apply, consider all of the defenses available to it, including rebutting the presumption, which we've covered at length in this presentation, but also limiting permanent disability exposure. One way to limit permanent disability exposure is to look at apportionment and non-industrial factors in the case of PTSD presumptions, but also go back to the basics of Chapter 1 of the AMA guides and look at the permanent disability. These presumptive injuries, oftentimes, they have very high permanent disability, and they have very high permanent disability awards because the nature of the injury, cancer, heart, they rate much higher than, say, a finger injury. But oftentimes, that rating is not necessarily in sync with the person's actual impairment. And by that, I mean the decrease in the individual's ability to perform common activities of daily living. Those include self-care, communication, physical activity, and so on. So the person may be highly functional. They may have no symptoms and no impairment, or very little, as a result of a heart trouble they didn't even know they had, or a cancer that has been medically cured. They may still have a high permanent disability level, even though it does not impact their activities of daily living. So look at Chapter 1 in those cases, because Chapter 1 also says that someone who has a 30% whole person impairment rating should be considered from a clinical standpoint to also have a 30% reduction in their general functioning, as represented by a decrease in ability to perform activities of daily living. Many of these presumptive cases have high whole person impairment ratings, and sometimes, fortunately for the individual, they have very few, if any, impairments. So if the two don't line up, we can ask a doctor to provide an alternative rating or an alternative impairment based on the actual reduction in general functioning, as opposed to what's the assigned rating under the WPI. And we use Alvarez-Guzman, which is the line of cases that usually benefit the employee, but in these cases can benefit the employer. And what comes around goes around. So Alvarez-Guzman should apply in every case, whether it causes the impairment to go up or down. So this has been a somewhat advanced level of workers' compensation coverage. So you very well may have good questions, and no question is turned away. We welcome them. Just find your closest RTGR law office, the one closest to where you work, and send an email with your question or questions, and we're happy to answer that. And we will try to get to it right away. As I've stated before, just find your closest office and then jot down that email address and send your email. We'll be happy to answer it. The email goes directly to our most senior attorney in that particular office. If you are a claim adjuster or administrator and you would like continuing education credit for participating and following today's webinar, we welcome that. Just send a email, if you will, to newsletter@rtgrlaw.com. That email address goes to our newsletter team, the folks who put out our quarterly newsletter, and they have certificates of attendance ready to go. If you put CE credit in the subject line, they'll know to send you also in the email, please say the date and time that you watched the webinar. Once we have that email, your email will serve as our record that we have to keep that you actually attended the webinar and participated. And we will then send you the certificate. And if you don't mind, we will also add you to our newsletter email list. This only comes out once a quarter. We don't send out a lot of emails, just once in a while from this newsletter address. We'll send you one of our quarterly newsletters. Our last one came out fairly recently, and we of course discussed COVID-19 and the compensability of workers' comp as it applied there. And many people found that very helpful. So that's how you get your continuing education credit. If you would also like a copy of this PowerPoint, we will turn this PowerPoint into a PDF, and you can email that same newsletter address and just ask for a copy of the PDF. And when we send you your certificate of attendance, if you'd like one, we'll also send you a copy of the PDF, no problem. My name is Tom Richard, and I'm the managing partner of RTGR Law, and I've been practicing law for quite a while, as have many of our attorneys. We pride ourselves being the statewide law firm that tackles the most challenging claims and controversies in workers' compensation and civil subrogation and in employment law, especially as employment law overlaps with workers' comp and civil subrogation. So for example, where ADA and the FMLA are impacted by a workers' compensation injury, we live and breathe in that area. And the more complex the case, the more we like it. So we have a philosophy that winning for our clients helps our clients achieve their core missions of teaching, serving, and caring for people, creating jobs, building communities, and moving California forward. A lot of our clients are hospitals who are working overtime right now to care for people. We represent a lot of school districts. We represent a lot of cities and counties and fire departments and police departments and people who are doing good work in California, employers who are creating jobs, and we take a lot of pride in that work that we do for them. You can follow us on LinkedIn and Twitter, and we'd love you to do that. Connect with us on those platforms. We post our updates and a lot of the information that we have in our newsletter on those platforms as well. And you can find out more about us by visiting our website, rtgrlaw.com. Thank you for participating. We look forward to getting your questions, and please, everyone, stay safe, stay healthy,